Part payment of debt. In case law, promissory estoppel has been invoked in situations concerning continuing obligations, such as rent or maintenance. It has not been applied in situations where there was a one-off payment, such as pre-existing debt. However, the Obiter remarks made by Lord Denning in D C Builders Ltd versus Rees suggested he would consider it possible to apply promissory estoppel to a debt if the debtor had acted equitably. Now, this approach presents possible conflict with earlier decisions regarding part payment of debts. Foakes versus Beer 1884 applied the controversial pre-existing duty rule in the context of part payments of debt. It is a leading case from the House of Lords on the legal concept of consideration. It established the rule that prevents parties from discharging an obligation by part performance, affirming Pinnel's case 1602. In that case, it was said that payment of a lesser sum on the day, that is on or after the due date of a money debt, cannot be any satisfaction of the whole. Let's look at the facts of this case. The appellant, Dr. John Weston Foakes, owed the respondent, Julia Beer, a sum of £2,090 and 19 shillings after a court judgment. Beer agreed that she would not take any action against Foakes for the amount owed if he would sign an agreement promising to pay an initial sum of £500 and pay £150 twice yearly until the whole amount was paid back. Foakes was in financial difficulty and with the help of his solicitor drew up an agreement for Beer to waive any interest on the amount owed. She signed. Foakes paid back the principal but not the interest. Then Beer sued Foakes for the interest. The question was whether she was entitled to it, despite their agreement that he would not need to pay it. Was the agreement made for part payment of the debt, excluding the interest, enforceable? The House of Lords accepted that the plaintiff had agreed not to sue on the judgment at all, even for the interest, but that this was not enforceable as the defendant did not provide good consideration for this promise. The decision in Foakes versus Beer 1884 upheld the principle outlined in Obiter in the Pinnel's case 1602. If a fixed sum is owed, then payment of a lesser sum can never be satisfaction for the full amount owed if no consideration has been provided, such as early payment or additional goods. However, it should be noted that the remarks made in D C Builder versus Rees were made Obiter, and that Lord Denning did not argue that a creditor should never be allowed to enforce payment of the balance of a debt, but merely that he should be limited if it would be inequitable. Clearly, in that case, the creditor was entitled to claim the balance as it was equitable on the facts. In High Trees, Lord Denning took the principle of promissory estoppel and applied it to the case at hand. He said that in Hugh's case, as well as in High Trees' case, there had been a promise made that was intended to be binding, intended to be acted upon, and in fact acted upon. Such a promise should be binding insofar as its terms properly apply. Interestingly, this approach extended the notion of equitable waiver into the area of part payment of debt. What are the justifications of the contradiction of the decision in High Trees with the one in Foakes versus Beer? According to Lord Denning, Foakes versus Beer was decided on common law principles, ignoring the role of equity. The decision in High Trees could be reconciled with Foakes versus Beer in that promissory estoppel will simply suspend the debtor's obligation to pay rather than extinguish the creditor's right to the balance of the debt. However, if in reliance on the creditor's promise to accept part payment, the debtor had spent the money he would have used to pay the balance, it might be inequitable for the creditor to go back on his promise to accept part payment.